All right. Well, welcome. In my quick welcome this afternoon, I forgot to welcome all our guests from out of town, not only to the law school, but to Tulsa. We're really proud of sort of a resurgence going on in Tulsa. There was even a story in the New York Times, which we don't get that often, about Tulsa. And for those of you who are visiting from out of town, our speakers, and if you have some free time tomorrow morning, visit the Woody Guthrie Museum. My husband Ken back there would appreciate that little ad. Really, it's a great place. And Chimera Coffee Shop, which is right around the corner, which is not far from where you all are staying. So I am Janet Levitt. I'm the Dean of the University of Tulsa College of Law. It's a true pleasure to have our guests, our speakers, our faculty. I see lots of students. Rumor has it you might be getting extra credit for being here. So I don't know, is that coercion or just the norm of wanting to be here? I don't know. I had the real pleasure of being able to spend about an hour this afternoon in the conversations that I just found very interesting, from gourmet chefs to madmen. And I hope to be able to spend a little bit of time tomorrow as well. I have been very, very blessed over the course of my education and my career to be surrounded by and taught by just really, really terrific teachers. And this year I'm now 20 years out of law school and 25 years out of college, which I can't believe. And over all that time, I've had tremendous teachers, but it's a rare teacher that I sort of think about every day. And Professor Ellickson, you are the exception, because universities are ripe with social norms. One of the norms at this university is there are only 2 people in the entire university that get a reserved parking spot: the president and the chair of the board of trustees. Now, usually when I get to school, I get here early enough that I get a parking spot. But I often have to leave during the day to do the kind of things that deans do: have lunch with people, schmooze, get to know people. And the reality is there is never a parking spot when I come back. So I am brought back almost every day to the way you started property class, and talking about property as being a battle over parking spots, because I do battle. I'm sorry for the students who are here if I've ever sort of jumped and breached the norms in taking the spot in front of you or in queuing for parking spots. But I really do think about that discussion and sort of that notion about law and rules almost every day. And as you know, as some people here know, you also have influenced greatly my scholarly career, well beyond just my own parking lot frustrations. In my area of international law, particularly commercial and financial law in the international realm, many would question whether international law even exists. And there are many, many dark spots or dark legal spots. And in my research, what I found was a high degree of order without law in homogeneous niche communities that were not as geographically concentrated as your ranchers and farmers, but your book and your insights really helped me think a lot about what was going on. And what I found when I took these ideas on the road to my colleagues who do international law is that your book, Order Without Law, really had almost an iconic status. Everyone had read it. Most people were citing it. Not just property scholars or land use scholars or even social norms scholars, but here international law scholars. And your next book, The Household, is already on my Kindle for my reading list on my sabbatical, which will be starting in June. I just want to say, as a former student, thank you for impacting me so much in the way that I think about my scholarly career, but also just in the way of thinking about my day-to-day human interactions at my home, in the law school, and in the various associations which I'm a part of. And so I know it's just a tremendous honor to welcome the Walter E. Meyer Professor of Property and Urban Law at Yale Law School, Robert Ellickson.
Thanks, Janet. One of the great pleasures of a senior faculty member is seeing students do well and so forth, and you plainly have. I should mention also, as Janet knows, but many of you don't, I have interests other than social norms, and one of them actually is the history of cities. So that when I come to a new city, such as Tulsa, which strikes me as an extremely interesting city, I do try to learn a little bit more about it. So I haven't yet, but I plan tomorrow to do a walking tour of downtown Tulsa so you have a better sense of this city. This is actually one of my passions that you will not hear anything more about in the remainder of my talk. Also, preliminarily, I want to congratulate Bob Spoo in particular for putting together a wonderful group of people. This is the creativity here is figuring out who you want to get to come, and also he's given us, I think, a fairly leisurely schedule and so forth, which is productive of interchange in the interstices of the conference. And also thanks to Barbette and the others on the staff who helped out with this. My topic is designed to help us understand how the world works. It's sort of a social scientific topic, not so normative about how the world should work, but just to give us a better understanding of how the world works, and it is about associations. In my title, Bob Spoo asked for titles about 6 months ago and whatever, and so I gave you a title, and I decided not to change it. But in fact, I'm going to change the sport. So I deeply regret that some of you may have come here because you are baseball fans and thought you would hear a lot about baseball. And actually, I'm going to switch to another sport. So please excuse me with that. So let's see if we can. So here is another sport. It is the most popular sport in the world. It is the sport of soccer, or called most places around the world, football. My guess is perhaps 500 million people recognize this photograph because, in fact, soccer is vastly more popular than baseball, and this was the most notorious incident in the World Cup this year at Brazil. The player, you see, Luis Suarez, is a great player, one of the top 100 soccer players in the world, perhaps top 50, and so forth. But you see him biting the player of a player on the Italian team. This got a great deal of publicity, partly because Luis Suarez had a history of biting, and this is a better photo. I can assure you I searched the web for the best photos I could get, and these are the best ones I could get, but this is a fairly dramatic photo of why Luis Suarez has earned the nickname of Cannibal. He did have a history of biting. Sometimes we have difficulty knowing what the rules of the game should be. I think many people in this conference are greatly conflicted over what the amount of copyright law there should be. There are many people who think there's too much copyright law, and there are others who think there's too little. But I think there would be a broad consensus about the amount of biting there should be on the pool. This strikes me as kind of a no-brainer. We want to have a no-biting regime on the field of soccer. And then the question is how we will achieve a no-biting regime. So this is, I think, an example that I've chosen because I think it nicely illustrates how the world works, which is what our goal is here today. So I'll identify 3 major systems we might use to control biting on the field of play in soccer. And the first two are very conventional and are familiar to everybody in the room who has studied social norms. Lawyers and law school people tend to be legal centralists. We went to law school because we think the law really matters, and that when laws are passed, everybody will march to the new rules of the game that the legislature has announced and so forth. And courts believe when they render a decision and so forth, this will shape the world. And this is I will trash this concept, but I don't think that the legal system is in fact always irrelevant. And an interesting question is when it does have purchase. I think there's a lot of purchase in tax law, for example. You have strangers, large amounts of money. Tax law really matters a lot. But there's another regime called informal norms, which is the central theme of this conference, which is informal rules of the game informally enforced. And those might come into play in any incident, including the one that I just pictured with Luis Suarez. And then there are the third one, which is has received less attention and is my main theme, which is that we live in a world where much of the rules of the game are created by organizations. I shouldn't say much, because in fact I regard organizational rules to be less important in the overall scheme of things than either law or informal norms. But they are my topic because I think they have been undervalued and ignored would be too strong and whatever, but that scholars run across organizations and perhaps pay too little attention to them in their place in the overall system of social control. So my main focus will be on the third of these three systems, which I repeat is the least important of the three systems, but still quite important in itself. Bob Spoo mentioned Thomas Hobbes, and so here he is. He is the easy whipping boy of legal centralism, because he famously wrote in the Leviathan stands for the state, that in the absence of the state, all would be chaos, life would be short and brutish, and so forth. And he adopted this view that many, many people have, particularly around law schools, that law is absolutely the center of order. This I regard to be basically false, I should say. There are many societies that are stateless, for example, on small islands in various places, which have no state at all, and in fact are quite peaceable because they work out things through more informal kinds of methods. But at any rate, law is important in some contexts, and I think it's important to try to figure out what they are. If you are a legal centralist, what you would think would happen in Brazil, because that's where Luis Suarez did his biting, would be that he would be indicted for a criminal offense under the law of Brazil, and perhaps subject to a tort action by the victim of his bite or something of that sort. I don't read Portuguese. I don't know whether or not there was any talk of these things in Brazil. My guess is there was none of it. That no one thought that this was an occasion, although this was a very upsetting occasion, no one thought that this was an occasion where the legal system should be brought into play. Some of you may know more read Portuguese better than I, and see some speculation about the use of Portuguese law. But that did not happen. How about the use of social norms to control the behaviors like biting on the field of play? And Janet has mentioned a book that I wrote some now 25 years ago almost about the interplay of social norms. And in that, I emphasize the conditions under which social norms would be most effective, and they would be among what I call closely knit groups. And I identify here on this slide some of the characteristics of a closely knit group to make it less vague. People have homogeneity of interest, small number of actors, prospect of future encounters. The reason these are important for social control is that to get social control system to work informally, you have to have good information about what's going on. And if people are repeatedly interacting and are small in number and so forth and homogeneous, they're likely to circulate a lot of gossip. Gossip normally has a negative valence in this world, but not to me. I regard gossip to be the way of the world, and to be a truthful gossip. False gossip is, in fact, biblically unsound and condemned in the Ten Commandments and so forth, but truthful gossip is an extraordinarily important part of social control in this world, and many of us spend a lot of our time engaging in gossip, and don't feel guilty about that at all. It should not have, if it's truthful, in fact, it should have a positive kind of valence. So good information helps a lot. The other thing about close-knittedness is that if you have a continuing relationship with other kinds of people, that means that they know that if they misbehave or they behave pro-socially, they do something great, that you will have lots of opportunities to take it out on them or reward them in the future, because they're going to contact you in the future. And therefore, if you are a law student at Tulsa, you know you're absolutely imprisoned by your reputation with your classmates and so forth, and therefore you have to behave soundly, or they will retaliate in the various kinds of ways. So, at any rate, this might have happened on the field of soccer play, and if it did, it would occur in the following kind of way, that soccer players know each other. They knew that Luis Suarez bit. They had good information about it. They could see it on the replay because it was replayed constantly, and they had available to themselves means of retaliation, namely, at the extreme, biting back, but I don't think they would do that, but roughing up Luis Suarez on the field of play. And we see this in sport all the time, particularly in baseball, where if there is thought to be an intentional brushback pitch of their singles hitter, the appropriate response is a brushback pitch of their singles hitter. It's very proportional. If it's the slugger gets brushed back and whatever. But that is thought to be in baseball the way we discipline misconduct. So sometimes social norms are at the field of play. What's interesting to me in this case is the dog that didn't bite. Namely, as far as I know, Luis Suarez is now playing again. My guess, to my knowledge, this is not happening on the soccer field. He is not getting roughed up because he bit in the past and whatever. Social norms about which I wrote my book and would thought perhaps would have been important in this area are not in play among the soccer players. They are in play in certain other sports, which is interesting, but not in this. Rather, the organization that took command of this situation is one called FIFA. FIFA is in the news today because FIFA is widely regarded as a corrupt organization, you should note on the side, but that has nothing to do with how it handled the particular Suarez instance. FIFA is a non-profit organization based in Switzerland, chaired by a notorious, I shouldn't say that, a controversial president named Sepp Blatter. And it immediately took command of the situation when Suarez bit and decided through its own procedures that it would suspend him from play for the rest of the world and also for a certain number of games into the future, because FIFA controls basically the leagues who make up its membership and so forth. So FIFA had that kind of power. And this was regarded, I think, by almost everybody who talked about this incident as the appropriate way to handle this conduct on that field. It was not to be handled through the legal system in Brazil. It was not to be handled by the players with self-help on the field, but rather the natural way to do it was to have it handled by an association, namely FIFA. And I don't know to what extent these other alternatives were seriously considered, but to my knowledge, they were not. So that's my subject of today. What is the part of the world that is controlled by associations? What is their role here? And I will argue that, in fact, they are more important in our lives than reading the law journals would make you believe. I thought about the adjective here because we have participants, and I stick with the adjective. These are two wonderful books written by participants in this conference about the role of social norms in world of potentially of copyright and so forth. And they are wonderful reads, and to me they were revelatory. They have lots of information about the world. But they do not, I think, develop ideas about association. So this is my, even though I regard these as great books, I mean to compliment the authors to the max and so forth, I think it is fair to say that when the authors, all three of these authors encountered associations, they didn't particularly take a hard look at what kind of association they had, why was the association doing what it was. So this is my constructive criticism, as we might say. So let me give some specific examples of that. Bob Spooth's great book about the world of publishing in the United States 100 years ago talks about something called trade custom. And Bob, I think, will talk about this more tomorrow. Trade custom was basically European copyrights were not honored by American law a century ago. And what publishing houses did in the United States is they would have a rule among the pirates, if you want to call them pirates, because they were not actually doing something illegal, is that the first pirate got the right to publish a book. So if there was Charles Dickens or someone was publishing something, and this sometimes worked well and sometimes it didn't, the first publisher in the United States who published the Dickens novel or something like that had an exclusive right informally, and it could not be invaded by other publishers. The puzzle for me, if you think about associations, is that the publishers could have created an association of American publishers, and you see some names that look like that, but they did not do that in any way to enforce the rule of a trade custom, a trade courtesy rather. And so this is a dog that is not barking that might be talked about. Cal and Chris's book is a wonderful tour of the world of fashion, the world of stand-up comedy, the world of cuisine, and so forth. And in all these areas, there are, in fact, associations, and I will show some of them that exist in some of these kinds of contexts. And again, if you're worried about knockoffs and whatever, an interesting question is to what extent did these associations get involved in trying to prevent knockoffs, and if they did, in what manner did they do so? And I think that is more connected to what we'll be talking about. So let me just show you a list of some associations. This is just the top of the list of journalism associations. We got a lot of associations out there in the world, and with the internet and so forth and websites, it is easier and easier to form associations, and we have associations galore. So there are a lot of them. There are scholars who have analyzed American culture who have stressed, important scholars who have stressed the role of associations. And two of them are Alexis de Tocqueville, who said a distinctive thing when he wrote about 1830, a very distinctive thing about American life is the importance of associations in American life. Some people call this civil society. And if you want to have a theory about what civil society is about, you have to have a theory about associations, what they do, and so forth. Another scholar who stresses associations is Robert Putnam, a name that many of the academics certainly will recognize, who wrote a great book called Bowling Alone, and he is interested in what he calls social capital, levels of trust and trustworthiness out there. And he uses membership in associations as a proxy for the existence of social capital. And he thinks that there's a decline in the Kiwanis Club or something of that sort, and he worries that there's a decline in American society. I'm not persuaded by that last thesis particularly, but he's very interested in the roles of associations. So being interested in associations is not all that quirky an idea. It is today. I was in Paris when I did this research to find an association just to see what they look like, and so I chose an association I'm sure you all know, the Association of Food Journalists. This was on the list of journalism organizations and whatever. So this combines a little bit the problem of plagiarism with the interest in cuisine, which some of the people in the room have. And it turns out, and this is a very interesting thing about the world, that many of these associations have something they call a code of ethics. And the food journalists have seen fit to create a code of ethics. And here you see some of the central provisions here. We do not plagiarize. We hyperlink. This shows you, the modern world. We hyperlink when we borrow. And we honor copyright laws, which is, I'm sure, will grate against perhaps Bob Spoo and Cal and Chris, who are less appreciative, shall we say, of food journalism. An interesting question in the world, whether codes of ethics make any difference in the world, or what is this, or is this just a posturing, if you will, by people in a profession to make themselves look good. And I know of no studies about that at all. There are a zillion of these codes of ethics, and in fact there are anthologies where you can get collections of codes of ethics, and whether or not they make any difference, I think, is fairly unexplored. I'm skeptical about whether they make much difference anyway in the world, but I'll say something about that. Here's my key slide. I'll show it to you a number of times, and what I will do mainly is offer a taxonomy or a typology of types of associations. This is not rocket science that I'm trying here, but it's a first effort to distinguish between different kinds of associations. And I will later offer a few thoughts, and these are not terribly well developed, about why we see one form rather than another. So that's sort of the interesting social scientific question is, what the devil's going on here? What are all these journalism organizations doing? Why are they taking the form that they do? These associations that I concentrate on are what we call membership associations. I have a colleague at Yale, Henry Hansman, who has written a lot about nonprofit organizations, and this is a phrase of Henry's. Membership associations are organizations that deliver services to their members. Members typically are required to pay dues. If they don't get dues, they get bounced out. These associations, all of every type, we'll get to the no association state soon, but associations of most types elect officers, have newsletters, they have websites these days, they may have an annual convention and so forth. Many of you belong to a number of these, and so those are commonalities of all these kinds of all these associations. My guess is most of you, if you think about it, belong to a half dozen or more associations. And you kind of fell into it. You never thought that you'd be an association kind of person, particularly. The students probably are not yet in that associations, but just wait. And I'll give you an example of the kinds of associations that you don't think about a whole lot. You're probably members of an alumni association or something of that sort that sends you some newsletters or something of that, so that's an example. Religious organizations typically are of this character and whatever, and a large majority of Americans are, of course, religious to some extent. One of my specialties in confronting the work of associations is in that of homeowners associations, condominium associations, and so forth. About 60 to 80 million Americans live in those kinds of associations, and these actually are associations with real power and so forth, and so you may, at some point in life, be a member of those. Labor unions would be another standard example. So if you think about that, many people in the room are associated with some professional association. I think the Bar Association, am I right that the imprint of the Bar Association of Oklahoma is on us today here, Janet?
It is on us.
So that's another association to which you may belong. And if you are a humanities person, you might be a member of a modern language association. So think about these associations. You actually do belong to them, and that's why they take the form that they do. In law, I claim we don't have a good overarching theory of associations and also the legal structure of them. That is, we can get judicial review, perhaps, of what associations do. We just heard from Catherine Fisk that the Writers Guild doesn't want that. I'll talk about the Writers Guild further. They were able to resist judicial review, but in fact there's a fair amount of law about the review of what associations do, certainly of condominium associations, I can assure you. But we don't have a lot of scholarship about this or much theory. I contrast that with business associations. We have in law schools, those of you who are not lawyers, required courses usually in business associations that students have to take. We have an enormous amount of writing about the theory of business associations and so forth. People win Nobel Prizes for studying business associations, Ronald Coase I'm thinking of, and whatever, but we don't have much attention paid to membership associations, so that's why I'm emphasizing them here today. Okay, so here are 4 states of the world that is a starting point anyway for thinking about these associations, and in red I give examples of them. And these are preliminary forays into this. As I say, there's not much writing about this at all. One interesting state of the world is the absence of an association in a context where it looks like people might gain from having an association, but they didn't create one. And I mentioned now 2, drawing off Bob Spoo's books and Cal and Chris's books, 2 situations where you might have thought there would be an association and there wasn't, as far as I can tell. One is to organize the trade courtesy that Bob will talk about, which is the entitlement of the first publisher, the first pirate, to have exclusive rights to a European work. There were some associations in that day, but as far as I can tell, there were no organized associations. And what people would do is I think they would do it informally through norms. Similarly, at that time, although authors were having their works pirated, and Bob's book emphasizes James Joyce and Ezra Pound and other very famous modernists, as he calls them, the remedies against that pirating at that time were not some kind of associational action by an association of authors, but rather Bob reports there was Joyce, in sympathy to Joyce, 184 people signed a petition or something like that, but it was a one-shot kind of thing. It was not an associational action where you really have an institution put into play to defend authors whose works are being pirated. So again, interesting about why you see what you do, and I'll offer a thought or two about that to come. Comedians. We have in the room here with Cal and Chris the world's experts about property rights among comedians. And I think it is to say, they can correct me if I'm wrong in the question and answer session, that comedians do not like having their jokes stolen. They feel very proprietary. There may be, as I think I heard Chris say, that you think there maybe should be a little bit more sharing of jokes than there actually is. At any rate, the norms among comedians is jokes should not be stolen. So I was able to, doing research on this, look up to see to what extent there are associations of comedians. And I came across only one, that is, I Googled on it, namely that there is indeed a National Association of Comedians. On the other hand, I looked at the news section, the news tab, and the forthcoming conference tab, and there was no news, and there was no forthcoming conference. So it looked to me that this was a defunct organization. So I don't want to defame the National Association of Comedians, but it looks like there's an absence of an association for comedians. So then the interesting question arises, since you had an organization and you're worried about the pirating of jokes, why didn't you mobilize your association? And comedians did not. So I'll offer some thoughts about why perhaps they did not. Strictly social associations. This is reluctant to say strictly social because actually I think they aren't. But I do think there are certain organizations that don't engage at all in what I'm going to call social control, which is the overall thing I'm interested in here, to what extent they try to control behavior. The weak and strong associations, number 3 and 4, do. The second, associations exist as associations, but they don't do anything about social control. And I think alumni, I'd be interested if somebody in the question and answer can offer a situation where an alumni association tried to discipline a graduate of a school for rooting for the wrong team or something like that. This to me strikes me as improbable, but perhaps it occurs. I also list an association that actually I was an officer of. This is why I chose this odd one, as I actually know what this association does. And what it does is it holds social gatherings, conferences where people present papers. Many of these associations have national, the annual convention is the big deal and whatever, and that's true for the American Law and Economics Association. But there is no, in that association, I can assure you, no arm to make sure that law and economics people behave like good law and economics people. And a big problem in this world is plagiarism, for example, and you might think that if there's plagiarism within law and economics, that the Law and Economics Association would mobilize itself to get the plagiarist and whatever, and let me assure you, it's not on the table. So that's what a strictly social association does. I do think social associations are actually important in the field of social control because they help people in a group get to know each other better. And if people in a group get to know each other better, they're better able to use gossip and the other kinds of sanctions to discipline people. So that, in fact, if somebody were to plagiarize in law and economics, the fact that these people know each other, in fact, would make the negative gossip more effective than it otherwise would be. But most of my attention will be played to numbers 3 and 4, and you can see this is a very profound distinction here between weak and strong association. So let me tell you what I mean by that. Many of these associations, as I noted, have codes of ethics, perhaps entirely vapid codes of ethics, but they publish on their websites codes of ethics. And if they do, they qualify not as strictly social in my ballpark, but rather as associations that are actually trying to announce rules of behavior for their members. They're not trying to enforce them. They have no enforcement mechanism and whatever, but they declare rules of behavior. And that may affect the world as well, because people may point to those in other contexts and so forth. So these codes of ethics conceivably have a little bit of bite. We have Bob Spoo, as you may know, is not only a lawyer, but he's also a PhD in English, I'm going to say, and he has invited here today some humanities folks of the sort that law professors rarely rub elbows with, and I can say it's such a thrill to have them here among us. So I have chosen as an example of a weak association the Modern Language Association, which is the representative of one of the major organizations of humanities professors, teachers of English, and so forth. So I asked the people who are members of the Modern Language Association, are you aware that you have a statement of professional ethics? And the answer is, okay, Meredith, who will speak.
I work for the MLA, but I didn't know.
Not aware. Okay, this might support the hypothesis that codes of ethics don't have a lot of purchase out there in the world. The fact that people don't know they have. But I list it as a weak association because it turns out it has a statement. If you read the statement, they don't like plagiarism. They want people to attribute, if they borrow, to attribute work and so forth. So I'm not surprised by what they say on the merits. To my knowledge, however, they have no norm. That if a plagiarism incident arises, and they arise all the time, we read about them in the newspapers sometimes when scholars do it, it's a serious problem on campus, as you know, because in the current world people can download papers and whatever. Why doesn't the Modern Language Association have a tribunals so that's the question for you. They don't engage in that. So I'll offer a few thoughts about that, but it's the kind of question that I want you to to think about. Okay, now let's talk about strong associations, and these are, I think it is fair to say, the most important associations when social control is concerned that we have. And there are a lot of them that are strong, and when they're strong, they not only make rules, declare rules, but they set up some kind of adjudicatory mechanism within the organization that they control. They appoint the people who do the adjudicating and so forth, and they do something to discipline the bad people. They may also, and this is what Catherine indicated was true of the Writers Guild, about which I'll say a little bit more, they may try to keep these disputes out of court as well, which is interesting. They really want to be monopolists on the resolution of these disputes. At any rate, these kinds of organizations exist in many businesses, and you're always skirting with antitrust law. So let me just say a word about associations. Let's not think that associations are always good. Cartels are associations. The better organized they are, probably the worse off we usually are. Organized crime might be done through an association. Many of us would not like that to occur. So worry about the downside of associations as well as the upside of associations. So within the constraint of antitrust law, for example, you do have lots of rule enforcement by a variety of different entities. Much studied are the New York diamond merchants, who are overwhelmingly Jewish. The Jewish connection is thought to be part of the close-knittedness of this group, and there have been many studies by Lisa Bernstein and others. Since I mentioned Lisa, let me give you my own take on the evolution of social norm scholarship in law school, because Lisa was one of the pioneers. Here's my take, which is probably incorrect because I'm too close to it and have not been that close to it actually in the last dozen years or so. People knew social norms were important before I wrote and other people I'll mention wrote. Stuart Macaulay at Wisconsin was a person who wrote an important work of this sort. But in the 90s, roughly, there were 5 of us scattered around law schools, utterly uncoordinated, although we knew each other and appreciated each other, who made the case that legal centralism of the sort that Thomas Hobbes believed in was basically empirically wrong, that much of the world was organized through informal sanctions, informal norms, and so forth. And apparently, Janet, I have at least one convert in the dean here at the law school, Janet Levin. The 5 of us were, I was one, but Bob Cooter of my age group, and then 3 younger people all at the University of Chicago, but who were not at the time, Lisa Bernstein, who I mentioned, Richard McAdams, and Eric Posner. And we all pushed the case that basically a lot of the world is organized informally through informal rules, informally enforced with negative gossip and other such things. And our self-satisfied negative consensus was, and is extremely self-satisfied, is by around 2000 we had actually won that debate, that we had put Thomas Hobbes away. Now, many of you actually don't agree with that, perhaps, because there may be some legal centralists in the room, and the best thing we can have in the question and answer center is a statement by a strong legal centralist, because Bob hasn't invited intentionally an antagonist of this sort to be amongst us, but somebody who thinks that the role of norms is exaggerated. Anyway, we thought we had sort of won that battle and went on to doing other things, like for me, the history of cities and things of that sort. But there is a new generation of scholars, and many of the leading ones in this room, who are interested in applying these ideas in other contexts. None of the 5 names I mentioned knew a lick about copyright. I think it is fair to say, which opened a major opportunity for Bob and for Cal and Chris and others to run with that. So anyway, that's my self-satisfied view of the conquest by our ideas. This is the only conquest that actually I ever can claim in academic life, that we thought we won this battle, but I'm not sure that we in fact did. Okay, strong associations. Another set are sports leagues. Sports are, if you judge the importance of something by the fraction of pages that it gets in the newspaper, this is the Arthur Leff test. He wrote some articles about this some years ago. Sports are really important in the United States. If you look at what's on television and so forth, sports are really important. And sports are governed by associations and by strong associations, who not only make rules, but have mechanisms within themselves for enforcement. And they have, what's interesting about sports is very often these leagues provide adjudicators for the field of play. They provide umpires, referees, and so forth, and that's interesting, and that I think connects to some other and more ambitious things that they do. Also, I use the example of the Writers Guild of America. We have with us today as one of our participants, she just spoke, Catherine Fisk, who is the expert in the world on the Writers Guild of America. And this is the folks, a union of the people who write scripts for movies and TV and so forth. Trying to remember what my, oh no, I don't want to do that yet. And I'll say a little bit more about them shortly. One thing that associations do, even weak associations, is they provide the public good of trying to influence law. So if you are a lawyer, you're actually interested in these associations because they lobby and they bring test case litigation. That's one thing they do. They don't necessarily provide social control, but they do these kinds of things. So here are some examples of, in these worlds where I think there are weak associations, they are actually involved in trying to influence law, which is a different domain, not their own domain. Since Cal and Chris emphasized fashion, there are two important associations there. The first one is the association of the brand names and so forth. This would be Nike and Gant and all those kinds of things. And they have an association. Guess where they're located, by the way, if you want to have a trade association that engages in this. They're in Arlington, Virginia, I think. So this is where you would expect them to be located. And they provide the public good of lobbying for statutes and so forth. The other Council of Fashion Designers is sort of an honorific association of fancy people who can only be admitted to this association by invitation and so forth. And I think Catherine thought that knowing Diane Van Furstenberg or something like that was the key to becoming a member of this association. But they also lobby, and it turns out they both have, if you're interested in copyright, they both have a bill that they think is just a peachy idea, which has been sponsored by Charles Schumer, who's from the right state, if you're worried about fashion innovation and whatever, which is to provide more robust, not complete copyright protections, but much more protection against knockoffs than otherwise you would find. Fashion designs are knocked off systematically, as Cal and Chris describe in their book, and these folks are lobbying. So that's one thing that weak associations do, and you should be aware of. Also, as lawyers, be interested when you see in the name of a case a plaintiff that is identified as an association. Litigation also provides a public good. And it is for any one party, any one author, for example, to litigate against Google Books in the way that I'm about to describe would be a heavy financial burden. But if you can spread that cost among all the authors and whatever, then it makes a go of it. And a very important piece of litigation that is now underway, this is just a preliminary stage of the procedural stage of the case, is Authors Guild against Google. So unlike 100 years ago, and this is a puzzle for Bob, we now have an authors organization. An interesting question is what they do. One thing they do is they bring test cases. And what they don't like, what the authors don't like currently, is something the rest of us do like, I think, to a great extent, which is we can now go online and find on Google Books excerpts from copyrighted works where annoyingly, not annoyingly, but they think it's what they have to do because of fair use, you may get the table of contents and a little snippet there and a little snippet there, but you can actually access books online. Google's defense here is that this is fair use and so forth, and this is being litigated now in the Southern District of New York, I think it is. And this is an important, very important a piece of litigation for the copyright folks and whatever. But again, notice that associations are active here, even weak associations are active in this particular area. Okay, let's see if I can get to Writers Guild of America. I chose this not only because Catherine, I knew was going to be here as an expert in it, but as it happens, my son is a member of the Writers Guild of America, and actually chaired the strike task force at the Paramount lot in the strike of 2007 or 8 or something like that. So he knows this world, and he tells me about it. So I think I know a little bit about what's going on in this world, but certainly not as much as Catherine. You have seen in your life dozens of times, maybe not, next time look a little harder when something like this rolls by your screen, or how the writing credit is being given. And the basic point, this is for a show, Cheers, of course, which many of us are old enough to remember was an extremely popular show. The basic factual point here is this is largely a lie. Let's see if Catherine can live with that statement. The main thing about this is, in comedy writing, my son tells me that what you do is you have 9 writers on these kinds of shows, something like that. You sit around a table, you have a preliminary script that comes in that maybe was written by one of these folks, probably was, and then the 9 people go over it line by line. And you know, you only have 22 minutes you're going to show, whatever, and they go over, spend an hour on every line or something like that. Just an unbelievable amount of it, and they all contribute, and the original script that is drafted by one person actually does not is in tatters commonly at the end of the day. Doing research for this, I also found that the word in Hollywood is that Gone with the Wind, one of the most famous films ever made, was thought to have been written by some phrase like virtually everyone in Hollywood or something like that. That the reality is you have enormous corporate input, if you will, but you see things of this sort on screen. So what is going on? And it turns out that this is all governed by an associational rules, that this is a strong association. It's a union. It controls most of the good jobs, screenwriting jobs in Hollywood, and they have something called the Screen Credit Manual. There's an East Coast division, by the way, and I'll leave. Any questions about that division, I will refer to Catherine. They care about the phrases a lot. And so Catherine was just telling us about how and means something different than an ampersand, as I understood her remarks. So look carefully next time you see these kinds of credits. These folks care a lot. And why do they care a lot? Catherine has mentioned why. The persons who are listed are the ones who get the residuals, which is where a lot of the money is. Under the contract, they also, if they are listed, they get a bonus often, and often having yourself listed is good for your future job opportunity. So there's real money involved in this, and also glory on its own sake. An interesting question, which I've raised with some of the people here at the conference, is I think screen credit may not be a zero-sum game, which is a fancy way of saying, if you want to maximize the glory of writers as a whole, there might be a small number that maximizes the total glory. And rather, if you list 12 writers, for example, it looks like there was no auteur there, that there was the myth of the sort of the solitary genius creating something is shattered. And writers don't like the thought that people know that it's 9 people sitting around a table going over every line is the way these shows are generated. Rather, it is the brilliance of some small number of people. And so I think it is not a zero-sum game, and they are trying to get the optimal number through their rules. Okay, so the main thing, and the last thing I'm going to do is try to offer a what I'll call a positive theory of why we see what we see. And I will use this. I guess I'm running a little bit over in time, so let me not be dilatory about doing this. I will drop the fancy name Dimsetzian, which most of you is not helpful at all. Harold Dimsitz is an economist who wrote an important article in 1965 in the American Economic Review, where it's the most important article we have about transitions in property rights. And the assumption he made is that people are smart, that they are successful in overcoming problems of coordination, and that if new cost-benefit conditions obtain, that is, there's a change in the world, is that people will succeed in adapting their institutions to have the optimal institution to deal with those cost-benefit conditions. This is an extremely naive, optimistic, sunny, Panglossian is one term, assumption, which is often not true, let me just tell you. But it is a starting point for analysis here, which is if you're trying to figure out what you observe, for me, this is the natural starting point for analysis, and it allows for a deeper analysis to say those kind of conditions are not present, and we don't expect this kind of Panglossian result. But it has certain implications and whatever, as I will try to show you. And the reason it may be Panglossian is there are, as we now say around law schools, often transaction costs of people coordinating and their psychological dispositions and all these kinds of complications which, in fact, do exist in the world and may bar this kind of this return. But if you take a Dimsetzian assumption, here is how you explain why we see what we see on the list that I put up before. It costs money to run an association. You have to have a staff and so forth. And it may be that your other controls are so good that you don't need an association. So the Dimsetzian take on the reason the comedians don't have an association dealing with pirating of jokes is they don't need one. And the reason is, if the goal is negative gossip, there are few people in this world in better shape, better position to engage in negative gossip than comedians who stand up and badmouth the people who stole their jokes. And so if they have total confidence that that system works, why set up an association? Because you don't need one. So that's the Demsetzian explanation. It's kind of an upbeat, kind of rosy explanation. It may be false. It may, so the real experts on this could test them. A strictly social association, I do think, just to repeat, may make a group more closely knit, like the comedians. If they got together, their gossip might be more effective, but they don't even do that. Why does the Modern Language Association not deal with plagiarism incidents? It doesn't like plagiarism. Why doesn't it deal with it? And so the assumption, the Demsetzian assumption, which may not be true, but at least gives us a starting point, is the Modern Language Association recognizes it's not a very good entity to arbitrate these disputes, that there are better ways of doing it. The cases that appear in the newspaper are just devastating for the author who is reported, or the journalist who is reported to have plagiarized. These are devastating events because of negative gossip that will occur in their lives. Similarly, they may think a lot of this occurs in universities, that if at the University of Tulsa there's a plagiarism problem and whatever, it is best handled by the University of Tulsa through its own internal procedures. The Modern Language Association doesn't want to get involved. So anyway, that's the Demsetzians' take on perhaps why we see what we see. On strong associations, the Demsetzians' take is that it is cost justified, because this is this very sunny kind of thing, that although it's costly to run these associations and whatever, that there are net benefits for members on the whole. This is Calder-Hicks efficient, to get to talk in more technical terms, economic terms, for the members of the group to have a strong association. And the conditions that I think where you tend to see strong associations emerge are, here's my take at doing this, is that why do you see this among writers, for example, and not see it among authors and so forth, is that if you can police a gateway through which members must pass, which is true for the Writers Guild because it's a union that controls most of the good jobs, or is true of FIFA because if you want to play in the FIFA leagues, you have to pass through FIFA's eligibility rules and whatever. That gives these institutions real power, prevents free riding on its efforts, and so forth, and that is a feature of the situations where you see a strong associations. Also, there are certain contexts in the world where disputes are highly likely to occur and are badly policed by the people themselves. And I do think that sports and writing credit may be two such examples. Is that I don't remember too many people who, athletes, when they get called for a foul, applaud the referee for calling them for a foul. Their subjective take is they didn't do anything wrong, and so forth. So you have a biased decision maker, and this makes it very hard for the resolution of disputes on the field of play, although most of us played amateurish athletes, and we learned how to do this to some extent anyway. But referees, I think, are needed because you need a third party in there. My guess is, and I should quiz my son more closely about this, if you were to ask the 9 people sitting around a table who end up writing a script for a comedy show to indicate what percentage they contributed, that usually the total percentages would add up to 200. So you get my meaning here. Subjective evaluations of contribution are not too reliable in this context. So if that's true, then you'd have lots of problems. And the Writers Guild does say that their arbitration system handles 150 cases a year, which I regard as a lot of disputes. So this is a highly disputed area, and so forth. George Clooney, you should know, a name you may know, thought he should have gotten writing a film that I never saw called Leatherheads, and did not get credit and quit the Writers Guild about 5 years ago for not getting the credit, and so forth. Now, other conditions where you don't why don't we see this among fashion designers, chefs, and so forth? My assumption here is that they don't have a gateway, that it's just too darn easy. Anybody in a house can invent a new design for clothing or a new cuisine or whatever. It's just very hard to police entry and so forth, and that's relevant. And again, sometimes you don't see associations because people use self-help. At any rate, what impressed me, to return to my first slide and end this so we can have time for some questions, I'm just stunned by the fact that when this event occurred, a very disturbing event, the world seemed to know how it should be resolved, and the world knew that it was FIFA's to handle. And if you're a legal centralist, that should be a puzzle to you, because the world recognized that. Billions of people out there recognized that, and if you're a legal centralist, you didn't recognize that because you thought it should have been handled by the Brazilian legal system, but it wasn't. So, end of remarks. So what's any suggestions on how we handle this? I can just take questions, or I guess that's probably the simplest, or comments. I'm dying to have a legal centralist speak up that law is more important in more context than I have let on. This would be a useful countervailing view. Cal.
I'm not going to take that view, but I will ask, in some of these examples, like let's take that one, isn't there a kind of a shadow of law that's mattering? So okay, he bit the guy, and that's terrible, but let's say that he actually killed him by biting him. At that point, the legal system's going to kick in.
Yes.
So how do you deal with that problem?
I agree with that. Well, one thing I have in my notes but didn't say, this happens, I strongly believe in not reading one's remarks, but rather speaking extemporaneously, as you skip things that you should have said. These systems are not utterly independent of each other. They are interlaced in complicated ways, and I think it's useful to think about them as norms and separately from law, but in fact they are interdependent. And also, without law, it's unlikely you could have a World Cup, that there are a lot of contracts to be written to build the stadiums and hire the referees and whatever. So law is very much a part of the story here that gives rise to these associations, and I agree with that. And so an interesting question is, how is murder different? Biting is pretty bad, actually, but how bad would the bite have to be before the legal system might have kicked in Brazil? But in this case, I don't. Maybe the rest of you, many of you are aware of this incident. Whatever, I don't know any discussion in the newspapers about the legal process gets. Meredith.
I don't know quite where to go with this, but one of the things that's striking about sports is it seems to represent the law. Right, in the sense that it's a rule-bound system where part of what happened in the bite was the symbolic conflict became actualized in real injury rather than the injury of scoring on somebody else. And so I don't know where to, I mean, that's really an observation, but it seems to me that some of the desire for the consumption of sports is it's a fantasy world in which, like watching Law and Order, we get to see a figure for contest.
Well, it is interesting. I think sports, there's work to be done on sports, and there are a lot of sports fans out there who could do it. So, it's a nice combination. What's interesting about sports is, first off, there are very elaborate rule books often. There are assigned adjudicators, namely these referees and so forth. And the fact that they have legitimacy in governing the field of play is one of the reasons, I think, that everybody said the Suarez incident should stay in FIFA, that FIFA knows how to do adjudication, that they have a staff to do that, a slightly different group or whatever. So it's sort of natural, since they already govern the field of play, that they would govern response to that. So sports, I think, it's not, on the other hand, it's not law. You're using law in a way that law, to me, is a set of rules that is made by a state which assumes a monopoly of the use of force and whatever, and sports associations are powerful, but they don't do that.
So I'm just saying that some of the pleasure of sports is you get to see played out a relation and a theater of a relation to rules. And so, and this is just to respond to the comment about earlier today on directionality. It seems to be that some of the violation of Suarez was a violation against FIFA. So that's why FIFA would be appropriate to respond.
Let me say also, speaking of informal norms, is many of these great athletes make a lot of money potentially selling product endorsements. I think Suarez's value as a product endorser fell by a substantial amount of money, and that's because of our norms. That is, we look at this, and this is a way where our informal system worked, and whatever, is as we looked at this, and our market value for Suarez endorsement plummeted, and whatever, and so that was one of the major ways he suffered, actually, in this particular case. Leo.
Just a comment about that, and then a question. I think that's right with respect to some norm violations, but not others. So I'm thinking of Richard Sherman, the cornerback on the Seahawks, who after making a play that sent that team to the Super Bowl, just laid into how terrible the wide receiver was. And before, and it got replayed and went viral on the internet, and before Richard Sherman engaged in that trash talking, which was pretty clearly a norm violation, it got widely criticized. He had no endorsements. And a few months later, he was on the cover of I think the John Madden Sports video game, and he has lots of big endorsements for being a bad boy. But here's the question. The plagiarism discussion really interested me, and both during Catherine's talk and yours, I was thinking about judges who plagiarize like crazy, primarily from their law clerks, but also from lawyers. The law clerks aren't organized; the lawyers are. And I'm wondering if you have an account of why we see similar types of creative. Oh, and by the way, they plagiarize from other judges on the panel too, right? So, this is an opinion by Chief Justice Roberts, but Justice Alito probably contributed a lot of ideas to it. Do you have an account of why these different kinds of creative industries differ so fundamentally on a question like plagiarism, which would seem to have a lot in common as we go from context to context?
Well, it's interesting you refer to that as plagiarism. That it is more like I think some judicial opinions are more like corporate products, where you have a number of clerks and judges who contribute, but somehow we have this conceit of the creative genius, so it has to be attributed to one person, but not always. Round 2 was signed by the entire court. Let me see if I have anything useful to say about that. I think it is. It's largely an attribution issue rather than a plagiarism issue, as you define it. Jen.
So I'm curious, in your strong associations, whether you would object to the term private legal system, because that's what they are, and some have written about them. And I'm also curious. So that's. Yeah. I'll let you answer that and let the discussion go.
Well, when I faced this problem when I wrote Order Without Law some years ago, and I tried to define law as the product of a state which had a monopoly on the use of force over a given territory and so forth. So many of these organizations are not territorial, so they can't be states or whatever. So, but by my usage, I would not call it a system of law. It is a very strong system of social control, and I would call it a system of associational social control. It's one of these organizations doing it, and I think we might learn something by thinking about how that system is different from governance by a state, and how it is. There's a huge amount of law about review of actions of these associations, whether they're reviewable at all. And it's interesting, Catherine said that in the Writers Guild that they were very hard to prevent it from being reviewed. But in condominium associations, just to repeat that, they're reviewed all the time. And many other actions. If a university fires a professor, it's not unlikely that will end up in court and so forth. So I would try to say that's an associational control, and it makes my day because it's basically recognizing that the important part of the world is outside of the state.
Well, I guess I just want to add that in some strong associations, like for example one that I looked at, the International Chamber of Commerce, create rules for certain areas, like whether it's international arbitration or whether it's certain areas of like letters of credit, as boring as they are, that actually become embedded as sort of defaults into law.
Yes.
And that is a current that I think is interesting and sort of blurs that line a little bit between state-made law. I mean, this
Yes.
is private law that becomes by reference, by short references, would fit your definition of law.
Right. So I have this notion of hybrids where one system borrows something from another system, and law borrows from custom all the time. That's one thing, contract law or torts or whatever. And so that to me is a so these codes of ethics, for example, if they have any bite, you can imagine a piece of litigation where you have some incident and they would say, was there malpractice, a malpractice suit against somebody or whatever, and they would introduced into evidence would be one of these vapid codes of codes of ethics and so forth, and actually might make a difference. Also, they may be invoked in informal enforcement. Somebody who would otherwise not enforce would say, I think what you did is bad because I just reread our, I thought it was bad, and then I read our code of ethics, and now I'm sure it's bad, and I'll spread more gossip about you or whatever. Way in the back.
Have you thought about the networking of associations? And I have in mind the conservative networks and how they've played out politically since Lewis Powell's famous memo, generating kind of an echo chamber of conservative ideas and enforcement of who enters the realm of politics, who's a player, versus to the point that that's a strong network, I believe. If you look at the network as an association versus the progressives who can't seem to organize a household.
Well, I won't weigh in on whether the conservatives or the progressives have their act together more. But I do think that one thing I thought about is listing as an association would be a political party. And it's interesting, political parties are all around us and so forth, and I don't know much about the structure of political parties, so I just decided I would work on the Writers Guild rather than political parties, but that may be an association that is of some importance and so forth, and has some legal underpinning. So there are experts in election law of whom let me just say I am not one. So yes.
Okay, so let me be the Hobbesian, if not the legal centralist.
Okay. Good.
So imagine that FIFA, instead of enforcing the norm against Suarez, said now in every semifinal match. In every semifinal match, each team is allowed one bite per match.
Yeah.
So it's funny because it seems like what you're suggesting is that these norms of associations have importance, which the legal centralists need not deny. The legal centralists would only need to say that those norms just can't preempt legal norms,
yes.
that they can operate in the space in between them.
Right.
And it strikes me that the one association that routinely and vociferously attempts to exempt itself from legal norms, preempt them, and moral norms too, is an association that might not exactly fit, but it's the legal profession. So the legal profession seems like makes rules and sort of enforces rules, but also has other people enforce the rules, for them in the way that you were saying earlier. And so I don't know, maybe could the centralists say, A, I can accommodate the phenomenon that you're talking about here,
right.
just as long as they don't preempt legal norms.
Right.
And B, how would the legal profession, which does seem to exempt itself from, for instance, norms against associating with really bad people and working on behalf of them, how would they fit into this typology?
Well, I think we may be learning about the power of lawyers here rather than about the ideal normative structures. If the bar associations can't exempt themselves. I love your question about suppose there was rampant biting and whatever would eventually law come into play. And I do think that, and this came up earlier, is that these associations have to operate to some extent under the constraints of law. And in particular, a lot of these associations are would-be cartels. That's what they're doing. They're trying to limit entry into their profession. Bar associations might even be an example. I don't want to shock people in the room. But bar associations might do that. And in such cases, in fact, you might have antitrust actions or whatever. Similarly, labor law constrains organizations by workers. So we have real legal overlays, and you can imagine a situation where there was misconduct on the field of play of the sort that where law would be invoked. But it's interesting, the Suarez case struck me as a good example, and that was pretty egregious and whatever, and no one talked law at all as far as I know. Chris.
Great. So I think this taxonomy is really helpful, and I guess I'm interested in the distinction you see between 2 and 3 and 4 together, right? And so it seems to me that a lot of the distinction has to do with the fact that 3 and 4 use kind of negative social control as well as more explicit social control. And I think that if you look, if we include both positive social control and implicit social control, then I'm not sure that alumni associations and ALEA don't fit as well, right? So if you go to ALEA, you might very well be told, you should be running fixed effects versus random effects. Yeah, and you should be sharing your data publicly rather than privately, right? And if you go to your alumni association, they're going to be publishing, long lists of all the people who are giving lots of money as a way of engaging in positive social control, right, rather than negative. So I'm kind of wondering what, if these groups really aren't more like 3 or 4.
Well, I do think the distinction between 2 and 3 is very, very soft. My criterion was if they had a code of ethics, I stuck them in 3, and if they didn't, and since I regard these codes of ethics as pretty toothless and whatever, this is a pretty minor distinction. I don't think, since I do know ALEA, the association would never, as an association, tell someone to change their methodology. That conversation might be had in the hall with one individual and whatever, but it's just beyond the. You agree with that?
But it says the group of people who
the norms. It would be a setting where informal norms, and that's why these social associations are not irrelevant at all in the system of social control. Is they make tighter social groups who then can enforce, in this case, rules about proper methodology in economics or something of that sort. So, that's a good for you for pressing me on those distinctions. Chris.
So in comedians research, Jotan Oliar and I heard something which we didn't actually report in the article because we didn't hear it from enough people to have confidence in it, but it supports what you said about the National Association of Comedians, which is pretty much dead. And what we heard was it was ginned up by a lawyer. And one of the reasons it was ginned up was the lawyer had the idea of providing like group benefits for comedians. But one important early discussion was whether the lawyer could do anything for them about joke stealing. And so the lawyer did some copyright research and gave a report, and the report basically was, it's kind of sad, but it's going to be very difficult, at which point a lot of them lost interest and turned back to their norm system. So it was an episode that, the idea that they didn't find action through the association to be a replacement for what they do without the association. Right. One other note about, there was this comment that Cal made about murder. So, and then there was a comment about what happens when, the soccer league actually allows one bite. So there's an example of this actually, and it's an association that it permits tremendous violence and does not have problems with the law, and that's the National Hockey League. Most hockey games involve an assault, or many, and they're rarely prosecuted. So the Canadian Broadcasting Company has a very helpful list of hockey assaults that were prosecuted. The last one's in 2004. It was a sucker punch that resulted in 3 fractured vertebrae, a grade 3 concussion, vertebral ligament damage, stretching of the brachial plexus nerves, and serious facial lacerations. Okay, that one got prosecuted as assault, but pretty much everything short of that doesn't. And a lot of assaults, that a policeman would recognize as assault results in a 5-minute penalty. I mean, that's the total penalty. Right. So this is a massive exemption from the legal rule in the service of a very weird set of French-Canadian social norms.
Sorry. Okay, nice example. And I do think it's a reminder that at the extreme, and this, this reinforces earlier discussion, that the law might get involved, but the Suarez case was not regarded as sufficiently. I think it's relevant that the skin was not broken, as far as I know. It's actually was fairly minor. Yes.
And Dean Levitt's comments made me think about something to kind of pull this back to the FIFA component. And I read and write and speak Spanish relatively fluently because I grew up overseas. And I can think back to the Suarez incident. And it makes me think that there perhaps could even be a sub-denomination to column 4, and that's strong associations that make and enforce rules and oftentimes supersede law itself. And the comment about private law is what made me think about that. I remember there was a lot of rhetoric surrounding the Suarez incident where a lot of folks said that perhaps either the government of Brazil or the government of Uruguay, which is, Suarez's home country, might hold back and might not punish him because whatever punishment he received from FIFA would be worse. Not only in terms of, suspensions and, potential income loss in the future, but also in terms, like you mentioned earlier, of that social pressure that his peers would assert on him for whatever penalty they collectively suffered as a result of his misbehavior. If you could just comment on that, it seems like some of these organizations become so powerful that they can sort of take the place of law.
Well, I think my own view is, this is where I'm not, I'm less of a legal centralist than some in the room, I am sure, is that I think sometimes people intentionally ignore applicable law, that law does not always triumph over that. And the example I tend to use is academic photocopying. Many of us who teach, in fact, photocopy material for our class, now we kind of download it and put it on a website perhaps and whatever. It turns out there are a very complicated set of rules that the publishers pushed for and whatever that are contained in a committee report out of Congress. It's kind of an odd source of law about that. I can assure you that most professors assume without doing any research on it that whatever they're doing is fair use, if they even know the phrase fair use, and they photocopy like crazy. And law professors, I think, are much worse than people in the humanities. So maybe we can learn from the people in the humanities why they would be more law-abiding than law professors in this particular regard. But that's what I found in Shasta County. The most interesting thing I found in Shasta County is sometimes when people knew what the law was, that this was a private law rule of liability, it was not a criminal sanction or anything like that, they ignored it. They trumped it with their norms. They thought their norms were more important. And similarly, I think that happens in relatively low damage situations more than big damage situations. That happens more in the world than you might imagine.
One last question.
Last question. Good.
I'm happy to ask it, but I don't want to preempt. So the theme of a lot of these comments that you've heard has to do with what you mean by enforcing rules. And it seems to me as you think about your taxonomy, your Division 4 might want to have further subdivisions on enforcing rules in derogation of binding law, enforcing rules in the shadow of, to take your metaphor, law. And one of the things I'm wondering is if you did that further taxonomy, what theory you might develop for under what circumstances they can do it in derogation of law, and at what point it prompts intervention from some other kind of law. And the particular example I was thinking of is the Supreme Court argument just very recently having to do with the criminal prosecution of the fishermen who threw fish overboard, allegedly, in order to avoid the penalties from taking fish that he was prohibited to take, charged with destruction of evidence, gets to the U.S. Supreme Court that's kind of horrified by really is this really destruction of evidence, and then the government's position is, look, we have discretion about what to charge. This is a technical violation. Most of the time we don't. We have the U.S. Attorney's Manual, which for years has said we're going to prosecute the most serious, readily provable offense. And the court never really cared about it when it was all the drug weight stuff for years and years, and everybody knew it was going on. And then suddenly they're shocked to discover that it's different. It's the government making charging decisions, but according to their own internal processes and norms, and then it becomes controversial. And so I'm thinking back to the FIFA example of the one free bite, or the sort of what your theory would be about when external law suddenly starts to trump their rules.
Well, let me give you just one last example from Bob Spoo, for whom we owe this occasion, basically. The law of copyright in the United States 100 years ago was there was no protection of foreign works. And everybody knew that was the law. And publishing houses decided to establish a different rule. And I think that happens all the time, even though I think they knew what the law was, right? And they decided, in this case, a more protective rule of the first pirate, if you will. And I think that happens all the time. And to use another example, but it's one that I know a little bit more about. So I guess we're at the end of the day, and thank you all.